Hey guys, it's Attorney Amy. Today we're going to be talking about a topic that a lot of people have questions about, and that is, what are the most common mistakes that executors make? Whether you're a beneficiary of an estate frustrated with an executor that you think is making a lot of mistakes, or you're an executor nervous about carrying out your duties, today you're going to learn some of the most common mistakes that are made and how to avoid them. So the first mistake that people make is waiting too long to do anything. You have a will, it's in your hands, the person has passed away, and you see that you're named as the executor, and you do nothing. You don't take the will to court, you don't tell the beneficiaries, you don't hire an attorney, you ponder, what should I do next? Well, that's probably not the best way to proceed. So the best way to proceed is you take that original will down to the courthouse, or you give it to an attorney to help you with. Take it down to the courthouse in the place where the person died, the county where the person died, and you lodge the will. You give the original will to the court, and they have a registry where they keep these wills after a person has died. And that way, if anyone is a beneficiary of the estate, they can go to the county courthouse, they can see that the will exists, they can know what the terms of the will are, it's public, and you are not hanging on to that original will without telling anyone. Usually at that time, if you're the executor, you will also be interviewing attorneys. You want to find an attorney who's going to represent you. People may be scared that if they are the executor of an estate named in a will to carry out an estate, that they have to pay for the attorney's fees themselves. And so they don't want to pay an attorney to represent them. That's not true. In a probate of estates with a will, the fee for the attorney is paid out of the money in the estate. You do not have to pay your own attorney. So when you know that you're named in a will, you should interview attorneys, probate attorneys, and find one that you think you would have a good working relationship with, and retain that person, and they can help you start the process of probate. Another thing that comes up, and this is both for beneficiaries and for executors. Beneficiaries want to get their distributions. They know that the person who has died has made a gift for them, and they want to get that gift. And so it can be extremely frustrating for them to have to wait for the court process to conclude before they can get their money. Sometimes people put a lot of pressure on executors to give them an early distribution without a court order. That is a huge mistake. The executor is not allowed to give out any money of the estate to beneficiaries without a court order, an order for distribution telling them to do that. The executor can have a huge amount of liability if they don't get that court order first. So no matter how much the beneficiaries tell you, they're desperate for the funds, or they are mad at you for holding them, you may not give out those funds without a court order saying, executor, give this money to these people. What's the downside? If you give out the funds of the estate before the administration is at the end, before you get a court order, and a bill pops up in the estate that is a debt of the estate, let's say it turns out the person who died didn't pay their taxes for 3 years and you didn't know it, and you gave away all of the money already to the beneficiaries, and then the tax bill comes into the estate. Wow. That's going to be a really stressful day for the person who's the executor of that estate, knowing that they gave the money out before it was time, and now there's a huge bill and no money to pay it. Another mistake people can make is failing to make the portability election. The first question is, what in the heck is a portability election? Well, each year there is a certain amount that people can leave without paying any estate tax. It could be very high, like $12 or $13 million, or, in past years, it's been as low as $1 million. So it depends on the year in which the person dies, how much you can leave without any estate tax. When someone dies, if they don't use up their estate tax-free amount, they don't use it up, when their spouse can do something called a portability election. The executor can make it saying, I want whatever amount of estate tax money free from estate tax that didn't get used up to be transferred over to the surviving spouse. If the surviving spouse does not get remarried, then they can use that tax-free amount at their death. So that's a lot of words, but to make it clear with an example, if the husband dies and at the time of his death, he can leave $10 million tax-free. And that $10 million isn't used up because you can leave an unlimited amount to your wife. So let's say, or your spouse. So let's say you leave all of the money to your spouse. So you don't use any of that tax-free amount by giving that money to other people. Let's say in the year the wife dies, you can leave $8 million tax-free to other people. Then if she has made the portability election, if the executor has made it, then you can leave $18 million at the death of the second spouse. And so if you don't, there's a time frame for making that election. You have to let the IRS know that you're making a portability election. So if you don't do that, then you might miss the opportunity to save all that tax credit, save them from the death of the first spouse, and apply them at the time of the death of the second spouse. That would be a huge mistake, and there might be real consequences, legal consequences for the executor for failing to consider it and make it. Another big mistake people make is not following the terms of the will. Oftentimes our executors are friends, they're family members, they have their own opinions about how our estate should be distributed. And even if the will says how you want it to go, those people, our friends and family, the ones who become in charge of our estate, may say, I know it says that this is how I'm supposed to do it, but I knew Amy, and that's not what Amy would want. She'd want this other thing. And then they do something different than what you said. Now, later, when they have to report back to the court what they did, the executor is going to be in big trouble for not following the terms of the will. There is no varying from the terms of the will. That isn't allowed. And what are the consequences? Well, the person who varies from the terms of the will, the person who's been trusted to carry out these wishes, they're going to get in trouble with the court. At the beginning of a probate, you are required to file an inventory and appraisal. An inventory is a list of every single asset that was on hand at the date of death when the person died, and then the court appoints an appraiser called a probate referee who will say how much those assets are worth. So that's going to be their real estate, their bank accounts, their brokerage accounts, all of the things that might be their personal property, their car, all of those things need to go on an inventory. And sometimes people say like, oh, this car is only worth $2,000. I'm not going to put it on there. Nobody cares. Yes, people do care. It's very important. And it is wrong to not completely inventory the estate. Another thing people may say is like, well, it's so hard to get all of the information I need from the date of death to provide an accurate inventory. Beneficiaries and the court and creditors all need to know how much is in this estate, and the executor has an absolute duty within the first 4 months of the estate administration to create an inventory with the help of their attorney and get it appraised and file it with the court. Sometimes communicating with a lot of beneficiaries can be really difficult. The beneficiaries may be aggressive, they may be distrustful, they may have a personal dislike for the executor. All of those things are not uncommon. They're pretty common. And so the executor may say, I'm not going to talk to one of these people. I'm not going to talk to these beneficiaries, or I don't owe them explanations for everything I'm doing. And so it is a fine line. The executor needs to provide regular communications with the beneficiaries about what is going on with the estate. That can be done through their attorney, certainly. And if somebody was harassing the executor, that would be a different story. The executor doesn't have a duty to share all of the books and records, the tax returns, all of those things with the beneficiary. They don't have the obligation to constantly account each month about the ins and outs of what's going on in the probate estate. But they do have a duty to be in regular communication with the beneficiaries, regardless of any personality things that may exist. Probate is new to most people, and so mistakes are pretty common, or confusion. And that's why it's really important to have an attorney that you can get a hold of, that you can get access to who's going to walk you through this process. People often confuse what is a probate asset and what is a non-probate asset. A probate asset are all of the things that are going to be administered under the person's will. But, for example, if the person has a bank account and that bank account has a designated beneficiary, it says pay on death to Amy Harrington. Well, then when that person passes away, that pay on death account is not part of the probate. The assets in the probate are assets that do not have a designated beneficiary. And so sometimes an executor can be confused, and it is confusing, about which ones have designated beneficiaries, which ones are supposed to be inventoried, which ones are in the probate estate. And that is something that your probate attorney can help you with, to go through, look at all the assets in detail and figure out what is actually supposed to be in this probate estate. A problem that is very troubling when it arises is when the executor of an estate holds the money of the estate in an account that is not an estate account. So when an executor has funds belonging to an estate, they are supposed to get, with the help of their attorney, a new tax ID. A tax ID is like a social security number. So they get a new tax ID just for the estate. And they are supposed to go to the bank and open a bank account with the estate tax ID number in the name of the estate. So it could be Amy Harrington, executor of the estate of Sam Smith. But my name wouldn't be on there alone. It would be in my capacity as executor with the name of the estate. And so that is required, that the estate assets be held only in an estate account. Something people sometimes do, it's called co-mingling funds. They put the money of the estate into a bank account that they already have in their own name. Their intention isn't always to steal the money or to take it. They think, oh, I already have this account open. I'll just put the funds in there and then I'll do an accounting and I'll figure out whose is what. No, that is very serious. The person should be and can be removed right away for commingling funds. It's not something that's taken lightly at all. And the presumption when assets are taken out of the estate and put into an individual's name is that there is some wrongdoing there. That it was done for a wrong purpose. So it is incredibly important that estate assets remain in the name of the estate. Something else people try to do is get help from friends instead of relying on professionals. I see this a lot in the context of realtors. People will say, I know someone who's a great realtor, the friend of a friend, and I want to use them to sell the estate property. The person may have no experience at all with selling a probate property. They don't understand the court process. They don't understand the disclosures that have to be made. They don't know anything about what's required. And when I have to deal with those referrals, even though a realtor is a professional, it makes it very difficult, extremely difficult for people to properly administer the estate. So I would say probate is a highly technical field, unfortunately. And people usually, almost always, need to rely on the help of attorneys who work in this field, CPAs or tax professionals who know how to handle a probate estate, and also realtors who are familiar with the California probate process for selling real property. And when you have all of those people together, you know that the executor is protected because they're getting the right information, and the beneficiaries are protected because the estate is going to be administered properly. Sometimes an executor will make the mistake of ignoring a valid claim against the estate. So in California, the executor has the obligation to notify creditors, people you know who have a claim against the estate, and send them a notice to creditors and a creditor's claim form. You have an obligation to identify those persons or entities who thinks that they're owed money by the estate and let them know that the estate administration is open and that they have a right to make a claim. The executor cannot receive notifications that somebody wants to make a claim and then simply refuse to provide them the statutory notice. The period to make a claim the creditor has is 4 months from the date letters were issued, that's the date the person is appointed, or 2 months from the date of actual notice. But in California, If that creditor doesn't bring a lawsuit, doesn't bring a claim within a year after the person's date of death, in almost every case, they are barred from bringing a claim after that time. Self-dealing is another issue. And executors are often family members or friends. And so they have casual relationships with the deceased person, and they don't switch their minds over to realize that they are in a hyper formal and scrutinized process. And so they think, oh, here's a car. I have a used car, and I know a relative of mine would like to buy a used car, and I'm going to sell it to them, but I'll sell them the used car at a slightly lower price, and that's probably fair and good enough, and that's what the deceased person would want. No, you cannot benefit yourself, work to sell things to yourself in the estate when you're in the position of the executor. The executor is a fiduciary who has a duty to make sure that creditors are notified, that valid claims are paid, that taxes are paid, and that the beneficiaries get every dollar that they are entitled to. And so self-dealing should never be done, and that's something that can cause huge problems for an executor. So the mistakes that I see every day, both representing beneficiaries and executors, are that the complexities of probate are not fully understood by the person who's in charge of the estate. And so that is why you must have a competent probate attorney to guide you through the process, to make sure that even though sometimes things seem to make sense to you, it makes sense to you in a common world, you could do it. But those are things that you can get in huge trouble for. And so when you're the executor, you want to make sure that you're being fair to everyone, and also that you are protected so that no one can come back and say that you did something wrong. And that is why having a competent probate attorney is so valuable to an executor and also to the beneficiaries of the estate. Hey guys, it's Attorney Amy. I hope you liked that video. For more content like this, please remember to like and subscribe and hit that notification bell. I post content weekly. If there's topics or issues you think I should cover, please let me know in the comments.